Ready? 1, 2, 3, start. The petitioners are before this court seeking for the following reliefs. Issue a writ in the nature of certiorari, quashing the impugned order dated 22/12/2020, passed by the Honorable Principal District Judge, Dharwad in EP number 302 bar 2015, wide Annexure J, in respect of the stamp duty to pay as per Article 11 of the Karnataka Stamp Act. Pass any order as this Honorable Court deems fit on the facts and circumstances of the case. The grievance of the petitioners is that the petitioners are the decree holders and owners of the land bearing survey number 604, measuring 5 acres 5 guntas, under which an extent of 10,220 square meter was taken possession for construction of flyover by the National Highways Authorities of India. The competent authority had passed an award as regards the lands acquired. However, being dissatisfied by the said award, the petitioners submit a reference for arbitration on 31/10/2012 in terms of Section 3G, Clause 5 of National Highway Act 1956, hereinafter for brevity referred to as NHA, seeking for enhancement of compensation. The arbitrator has thereafter passed an award awarding compensation of rupees 14,186 per square meter, along with interest at 9% per annum. The respondent had made payment of part of the award and the balance of amount of the compensation not having been paid. The claimants bar decree holders have filed execution petition number 302 bar 2015 before the Principal District Judge, Dharwad, which was objected to by the respondent NHAI. In the said execution proceedings, an objection was raised that the award passed by the arbitrator not having been stamped in terms of Article 11 of the Karnataka Stamps Act 1957, hereinafter for brevity referred to as the KSA. The same could not be considered for initiating and prosecuting execution proceedings. The executing court void the impugned order dated 22/12 2020 at Annexure J was of the opinion that the award passed by the arbitrator is required to be stamped. The petitioner not having stamped the said document, the decree holder was called upon to pay the requisite stamp duty on the award within a period of 1 month from the date of order. Apart therefrom, the executing court directed the NHAI, the judgment debtor, to pay interest on the compensation awarded from the date of taking possession of the property, that is from the year 2002. It is this order that is challenged by the petitioners only, in so far as the direction by the executing court to make payment of requisite stamp duty on the award passed by the arbitrator, by contending that the same is not an arbitral award in terms of Article 11 of KSA. Shri S.C. Jainer, learned counsel for the petitioners, submits that the award which has been passed is as regards compensation for land acquired in the land acquisition proceedings initiated for and on behalf of the NHAI. It is only on account of compensation awarded being on the lower side that in terms of Section 3G, Clause 5 of NHA, the petitioner was constrained to approach the statutory arbitrator in terms of statutory arbitration contemplated under the Act, which is not a private arbitration, where the petitioners could be said to have consented for appointment of arbitrator, and as such, though the provision of Arbitration and Conciliation Act 1966 hereinafter for brevity referred to as the A&C Act are made applicable to arbitration under Section 3G of the NHA. The compensation awarded would not be an award in terms of Article 11 of the KSA, requiring it to be stamped, and as such, the arbitration award in essence is an award of compensation, which is in discharge of the sovereign powers of the state, and as such, he submits that the finding of the executing court that stamp duty ought to be paid in terms of Article 11 of the KSA is misconceived. Per contra, Shri Sagar Ladda, learned counsel who appears for NHAI, submits that since an arbitral award is sought to be enforced in the execution proceedings without the stamping made thereon, the same is inchoate insofar as it could not have brought in for execution without stamping. He further submits that the executing court ought to have impounded the document and levied penalty thereon instead of just directing the decree holder to make payment of requisite stamp duty, and in this regard he submits that the NHAI has filed another petition in WP number 104799 bar 2021. He therefore submits that the order of the executing court is not required to be interfered with as regards the direction to stamp the award, and this court ought to allow WP number 104799 bar 2021.